I want to thank our speakers, and it's my pleasure to introduce our New York speakers. The first one is Karen L. Campbell, who is a partner in the New York office of Lewis Brisboe and a chair of the general liability practice. She's a trial attorney with over 30 years of experience, and she has obtained defense verdicts, directed verdicts, and verdicts awarding minimal damages, as well as handling the negotiation of favorable settlements both before and during trial. And everybody's complete bios are in your course materials, and I'm just not doing justice for the brief ones. Next, we have Robert Kellner, who's a founding partner of Kellner & Kellner with his father, Joseph Kellner. Robert Kellner's legal career has included certain very high-profile cases. Early in his career, he served as one of the trial lawyers representing the students shot at Kent State University. Much later, he represented the estate of Maurice Gibbs of the Bee Gees in a wrongful death case, and Mary Ann Pearl, the wife of Wall Street Journal reporter Daniel Pearl, who was murdered in Pakistan. And you're apt to find him on the front pages of the New York Law Journal and also on page 6 of the New York Post. So those are our speakers from New York. Also, please know that the program is going to be 2 parts. First, we're going to have New York, and the lawyers are going to talk about voir dires from the defense and plaintiff side. Then we're going to have a interactive demonstration of how to conduct a voir dire, and the audience is going to participate as well, as you'll get to vote whether you would challenge the juror if you were on the defense or the plaintiff side. So pay attention, because we want to have your vote as well. And now it's my pleasure to introduce Belinda McCauley, the Executive Director of the Beverly Hills Bar Association, to introduce our California speakers. Thank you.
Thanks so much, Barry. I appreciate the introduction and really appreciate this partnership. This is one in a series of numerous CLEs that we've put together. And I know they've been popular with both of our memberships and all of our speakers, and certainly with our staff. So thanks so much for your time and dedication to this great series. We appreciate it. I have the honor of introducing 2 lawyers. I certainly cannot do them justice here in this time, and I won't try. I know you have their full bios, but suffice it to say that Paul Kiesel and Brian Panish, if there is a list of top lawyers, they have been on it. Very much at the national level, much less California and LA. They are both absolute superstars. For today's purposes, Paul is going to play a defense attorney, and Brian is going to stick with his traditional side on the plaintiff side. They both have a list of accolades, honors, and trial verdicts that is astonishing. So we are all very happy to have them here today. I'm also very aware that you're here to hear them and not me. So I'm going to turn it over to Bob Kellner.
Welcome to NYCLA 90210. It is a pleasure to be with such a wonderful group of people, and I want to thank both bar associations for working so hard and for assembling such a great group of people and wonderful jurors, one of which will be Belinda, who will be famous here on after for her role on this jury. So we are here today to talk about voir dire. How do we pick a jury? This is, I guess, for young attorneys, it is so intimidating because everybody knows that if you get the wrong jury on a case, you could face a kangaroo court or even worse, a lynch mob. So what is a voir dire, and what do we want to do to pick an effective jury? Voir dire, those of us who remember the French that we got in school, is to see and to say. And what you want to do in selecting a jury is to see them and hear what they have to say, because you have to be a psychologist as to who will be good and who will be bad. You want to let them talk. And your job, of course, is to find out what makes them tick. The statement that I'm going to make to all of you that I think will probably remain in everybody's mind is that when you pick a jury, you are not selecting a jury, you are knocking off the monsters. And what do I mean by knocking off the monsters? If I have a trial with my friend Karen Campbell, there is no question that she is going to look at each juror and she is going to see who it is that will be my favorite juror, the one person that I am dying to have on the jury, and she is going to excuse that person. So what each side really is doing is knocking off the monsters. So question number one, especially for the young attorneys that are just starting at this, is ask yourself the question, is this a monster? And if the answer is no, you probably will want not to spend one of your precious challenges in getting rid of that juror. What we are going to do is to really demonstrate the way that juries are picked in New York. And of course, in federal court, each judge has their own set of rules. So some of the judges may really let you go and ask questions, and some of them may give you very little opportunity to question the jurors. But your goal, of course, is to try to get rid of the worst jurors. And what you really want to do before you pick the jury is to make a decision. Is this a case where I need to try to win the case in Voir, or is this a case where you want to be neutral? And that's an important decision. One of my very good friends is a partner in one of the big law firms. When I say big law firms. And he told me that he was picking a jury right before the pandemic in a case where his elderly client was swindled by a partner out of tens of millions of dollars. And he said, Bob, what do you think? Is this something where it is a simple commercial case, or what are your thoughts? And I said, oh boy, if an elderly person is swindled, what I would want to know, and my field of practice, of course, is personal injury and wrongful death cases, not commercial law, but the concepts are the same. And I said, I would want to know from that jury, how many of the jurors had elderly parents or a close relationship with an elderly person? And do they know that that person may not be as sharp as another person? So immediately, by doing that, and his case turned out very well, by doing that, what occurred is that he made his client the victim. And many of jurors had an elderly parent or elderly person that they were helping to take care of. And so he hit a nerve in that way. In the fact pattern that we have today, Tom Crady, my client, the plaintiff, was struck by a falling ceiling in the Rams Maintenance and Construction Company stadium in Los Angeles. That probably would be a case where I would assume a falling ceiling resulting in a fractured skull would not be something where I would need to brainwash the jury in voir dire. And I would think about different problems on damages much more than I would on liability. Tom, in my case, has a fractured skull, and you will hear that he was both on The Bachelor and The Apprentice, and that will be an interesting aspect that we'll discuss in our voir dire. So how do we get rid of a juror? You get in New York 3 peremptory challenges, which means that you can excuse the juror for any reason that does not violate a discriminatory pattern, such as in the Batson versus Kentucky case. And Your peremptory challenges are extremely precious. You don't want to waste them because if you run out of challenges, you should imagine that you are going to have the worst juror imaginable come onto the panel and not be able to get rid of that person. So save your precious challenges. The second way, after peremptory challenges, is a challenge for cause, where a juror says that they cannot be fair, or there is a statutory reason, which I'm sure differs in different states, where the juror can be excused for cause and not count against your peremptory challenges. And Karen and I will be questioning the jurors with the thought that we will try to, quote unquote, talk them off and get them to admit that they could not be fair for some reason in the case. And then if they admit that, then we don't have to spend one of our precious challenges. So how do we know who we want to keep? On the plaintiff side, what I certainly in life, we don't want to use stereotypes. And I actually have only one stereotype where I will never let one of those people sit on my jury. And it is an occupational stereotype. And I'll keep it a secret until later on in this program. And we'll see who I will never let sit on one of my juries. But you want your vibes, you want your gut instinct, and the kind of person that I want on my juries for a plaintiff in a personal injury case, I want someone that is liberal. I want someone that is sensitive with a big heart. I want someone that's emotional. And I think to myself, is this a person that can let go? Because I want a person that is not going to be a buttoned down, rigid kind of person. Always win your case first and then deal with damages. Although there will be certain cases, such as a falling ceiling, where the plaintiff clearly is not at fault. Then, if the cases that I personally will try are cases where people are very severely damaged, I want someone that's not going to be against big verdicts. And there will certainly be a lot of people that will be, and you'll see how we will be handling that. I want someone who is working class rather than blue collar. I want someone who's kind of loosey-goosey, if possible. It is said that minority groups may be more sensitive to human suffering than other groups might be. But think of Clarence Thomas. If theoretically we had Barack Obama on a jury, I would look up at the sky and say thanks. If I had Clarence Thomas on a jury, I would probably want to cut my wrists if I ran out of challenges. So the issue certainly is that a stereotype may give you a percentage, but it is certainly not dispositive. We want artists, we want musicians or writers. What I want on my jury for the most part is the little guy. And what do I not want? I don't want corporate America. I don't want the executive vice president of a major company. Although I would guess that in California, you might get some very good people out of Silicon Valley. But just typically, I don't want the big guy, I want the little guy. So that executive vice president secretary may be a good juror. And the fact that she works for a large corporation is not dispositive. I don't want people that are militaristic. I don't want nurses or doctors because they're accustomed to human suffering, and that's not what I want, even if they're there for a very good purpose. I don't want accountants or bean counters. I don't want people that are going to be uptight and unsympathetic. And the way the world has evolved, do you know the main thing that I don't want on my jury now? I don't want Republicans. And probably people in the audience are smiling. And I will tell you a story. I tried a case which ended in a $40 million verdict. And one of the most memorable jurors that I ever had was a woman who came on the panel, and she was the wife of an iron worker, blue collar family. She was a jewelry artist, and she had a beautiful little flower tattoo on her arm. And she said, "Mr. Kellner, if you're going to give us gory details of this horrible accident, I don't know that I could sit through this." And then I saw on her bag was a campaign sticker for the Republican candidate in the area, in the county where we were trying that case. And I left her on the jury. And guess what? That verdict was a 5-1 verdict. In New York, it can be 5 out of 6. And she dissented on everything. And so the beautiful little flower tattoo was overwhelmed by the Republican Party, which certainly was the quote unquote tort reform party. And the Donald Trump party is not for jurors. I did a speech a while back, and I had the smile on my face when the defense attorney opposite me said, "Bob Kellner," he said, "I want the smartest person in the room, and Bob Kellner wants the dumbest." And I shook my head. No, I don't want the dumbest person. Bernie Sanders would be just great. But the person that I was opposite on that program was very much correct that I want a person that is going to go with our argument and probably not be the one to convince everyone else that that it should not be a case against my client. Another defense attorney said that what he wanted on the jury was his friends. And I thought to myself, because I had just been out to dinner with 2 of my best friends, one with Goldman Sachs and the other an orthopedic surgeon, and they are wonderful friends. They would do anything for me, except they would kill me on a case. And so on the plaintiff side, you don't want your friends, and you need to think about that. One of the things that definitely should be done in voir dire is if you have a big problem, workshop it and take the sting out of it. And you'll see that in this program, my client had a cocaine problem. And definitely it will be an issue that we will raise and discuss and workshop. And you will see how at least I would approach that. I'm sure Karen as well. When you're questioning the jurors, you have to be streety and watch their eyes and facial expressions and body language, and remember that they lie. Sometimes I had a trial where it involved the death of a young woman, a young mother. And we get jury sheets in New York that tell us all about the jurors, their backgrounds, etc. And there was a juror who was the head of the mergers and acquisitions department of one of the big law firms in New York. And when I saw that, it was in my mind, gee, I hope she doesn't come on to my jury. And on she came, and she held her hand out and said, Mr. Kellner, I can't be fair. I give you anything that you ask for. And my mouth smiled, and I knew that she wanted to get back to her mergers and acquisitions, and that was the way that she chose to do it. So remember that what they tell you may not be correct, and you have to be a good judge of character with regard to that. Be careful with jurors that are quote unquote kingpin jurors, a person that is so smart and dominating that they're going to run the jury, and you're going to get a one-person jury. And just be sure that if you are putting a Bernie Sanders on the jury, that is not going to be just one of the jurors, that that person is on, and that person will be favorable to you. You have to be careful not to get a lynch mob against you, and it's nice to have one for you. I tried a case in the Bronx a number of years ago where my client was a young African-American child that was run over by a car, horribly injured by a car driven by a German national. And the defense attorney got up and said, ladies and gentlemen of the jury, I represent a man from Germany. He was over here. Will you give me a fair trial against this child? And I'll never forget that one of the jurors looked at him, and when asked, would you give him a fair trial? Would he give him a fair trial? He looked my adversary in the eye and he said, oh, I'll give you a fair trial. And I think everyone in the courtroom knew what that meant. And of course, he was challenged off the jury and the case was settled shortly thereafter. I guess really the main thing that I do want to say is that all rules for selecting a jury can be broken. And what you need to do is to evaluate each person. I had a construction accident case where my adversary was someone that I had a very good relationship with. And when we walked into the room, he gave me an elbow and he said, Bob, I want that guy. And in the back of the room was this 6'5" tall man with a shaved head and a string undershirt. And his tattoos had tattoos. And he just looked like someone you wouldn't want to run into in a dark alley. And he eventually was placed onto the jury, replaced another juror. And his name had like 25 letters and they were all consonants, no vowel. And he just was the most formidable looking guy you ever saw. And he started out, and this was a construction accident case where I represented a construction worker. And he said, Mr. Kellner, I can't be fair in this case. I was just looking for a way to get rid of him because he scared me. And he said, Mr. Kellner, I can't be fair on this case. I would never go against a working man. And I thought to myself, wow, was I wrong? And the moral of the story is keep an open mind, judge each person individually. And at this point, I will turn this over to my friend Karen Campbell.
Thank you. Good afternoon, good evening, depending on where you are in the country. As defense counsel, I would say that the one thing I'm trying to do when I select a jury is get a jury who's going to listen to me. That doesn't mean a jury that's going to agree with me. Agreeing with me and listening to me are two totally different things. But I want a jury that's going to listen to the other side of the story. So that involves trying to get jurors who have an open mind, but who also are analytical and who are interested in listening to both sides of the story before they make up their mind. So in New York, you don't really, and I imagine this is most places, have an opportunity to try your case in front of the jury. So there's very little information that you're going to get with regard to really their leanings about the case so much. But what you are going to find out is whether or not they have real biases, because you can get some of that out. And you can find out if they have a problem with language, a problem with their health, if there's like an intellect problem that you and your adversary can ascertain, and whether, you know, they're going to focus and things like that. And as Bob has said, in New York, the jury selection is done without the benefit of a judge. So our four cause challenges, oftentimes the lawyers will be able to agree on most of the jurors that fall into those categories. But if there's any real dispute, then you can go and see the trial assignment judge or to the judicial hearing officer who is in charge of jury selection. But most of those people you're going to get off, and that keeps you from having to use your challenges to get off someone that should just get off the jury. For example, Bob talked about the mergers and acquisitions example. Well, to me, that person, after they say, I'll give you anything you want, can't be rehabilitated. So if my attorney that I'm trying to case with will not agree that that person gets off for good cause, then we're going up to a judge and we're going to have a judge question that jury, and that juror is most likely going to go. So what am I looking for? I'm looking for open-minded, not empty-minded juries. I'm looking at jurors who I feel will not accept what they hear at face value. I want the people who are going to agree that they're going to listen to the cross-examination of witnesses before they make up their mind. I want people who are inquisitive. I do want the conservative, less emotional types, the analytical types. So it's probably just the opposite of what Bob said he wants. I want to try to identify the right leader, because there is a right type of leader, but a leader can be dangerous to both sides. And I don't want the followers. But again, there's a wrong type of follower and a right type of follower. Obviously, if they're following your side of the case, they're not so bad. But you need to be very careful when you're trying to figure out who's going to be the leader in a group and who's going to be a follower. I don't follow too many stereotypes. As a minority lawyer, one of the things I always like to say is I can talk to my people. So I don't buy into a lot of stereotypes about minority groups, but I do want the white collar juror. And generally, you're not going to get that person. They will, like the mergers and acquisition potential juror that Bob talked about, they will talk themselves off the jury. They're too busy. They have something going on. They need to travel. They will say or do something that will make it impossible. So all those jurors typically walk off. I want people on the jury who are going to feel capable of engaging in deliberations with others, as opposed to the person who's going to sit quiet in the room and who's not going to raise any, hopefully, the points that the defense has raised throughout the trial. I try to be informal. I tell jurors oftentimes this is as close to my personality as you're going to see, because this is a little less formal point in the trial. I try to be friendly. I always want to be the nicest person in the room. I want to come off sincere and candid. And that's because if I want the jury to listen to me, jurors are people, they're humans. And people that you trust and that you like and who you find credible or usually is the person that you're going to listen to, what they have to say, what their argument is. And so I always start trying to build that relationship just from jury voir dire, because during trial, they may see some questions that I'm going to ask that are difficult questions. And I also tell them that there are going to be some difficult questions asked, particularly in a case like this where we have someone who has drug use, that, you know, there are questions I'm going to ask of the expert and of the witnesses that maybe you wouldn't ask someone at a dinner or on Sunday church, but I'm required to do it so that you can get all the evidence before you so that you can make a decision based on all the evidence. And I asked them, will they hold that against, my client? And I've had cases where, I've spoken to the jurors after a verdict has come in and they've told me, oh, no, you told us you were going to be mean. So, already the expectation is there. It's less striking to them when a difficult cross-examination is happening. The important thing is to be authentic and to be authentically you. You don't want to be an egomaniac, but you also don't want to try to adopt somebody else's style. It's interesting to go and watch other people pick juries and actually try cases. And there's things that you can probably incorporate into your own style. But at the end of the day, you have to be yourself. And that's how you speak. That's how you conduct yourselves. That's how you move in the courtroom. That's how you dress. Be uniquely yourself. I think authenticity is also helpful when you're asking someone to listen to your arguments, to listen to your questions, to follow what you're saying. I try to also be short. And this is one of the benefits of being defense counsel, is plaintiff's counsel does the heavy lift with the first round of jury selection. So they go on. And I've had some, talk about the flag and the Constitution. And then you can come in and say, look, I'm not going to waste your time. I'm going to go right to the pertinent questions that I'm going to ask you. And I'm going to keep it short and I'm going to keep it simple. And I start that with the jury voir dire so that I look like I'm the person who's not wasting their time. Getting jurors who will listen to you, who will listen to both sides, who will delve deep, who will evaluate everything, will not make up their mind before they hear all the cross examinations, particularly because the defense goes second for most of the trial, except for summation when you go first, is very, very important. I've had 2 ceiling collapse cases, and this fact pattern doesn't give me much to work with in terms of what the defense would be on liability, because it just doesn't discuss that at all. So a little handicapped that way. But in these cases, I've had ceiling collapse cases, generally speaking, in the bathroom seems to be where they all fall down, where being able to find jurors who are going to delve deep resulted in a $27 million ask of the jury by plaintiff's counsel, resulted in an $8,000 verdict, and where another 20-something million asked by plaintiff's counsel on a traumatic brain injury, both of them with traumatic brain injury claims, resulted in a verdict that was less than $1 million. You have to get jurors who are going to listen to your side of the story. And in both of those verdicts were against minority plaintiffs and minority venues, so to speak. So, although minorities may be thought of as being particularly generous, that doesn't always have to be the case. And other than that, I pretty much agree with everything that Bob has said. We're the other side of the coin. Bob, any more that you'd like to add to that?
No, thank you, Karen, for explaining the demise of the Roman Empire the way that you have conducted it. And at this point, and what I think you will certainly do is to conduct a jury selection in a very rational and logical way that is your style, and not to be obstructionist or nasty, I think is the best way for an attorney to be on either side of the fence. But at this point, I think we are ready. If we could technically do that right now, Dallaire, and have all of our jurors come on, and then we will conduct our actual voir dire.
If you are a juror, if you like and want to share your video, that would be great, because I think people always like to look at people's facial expressions when they're answering questions. And the fact pattern is as follows, and it's on your screen also. Tom Crady, a 40-year-old federal prosecutor in the Southern District of New York, was becoming bored with practicing law. Well known to the public through his appearances on the reality shows The Apprentice and The Bachelor, he toyed with the idea of entering politics and writing a book about his experiences. Ultimately, however, he decided that political campaigns had gotten too ugly, so he decided to follow his passion as a foodie. He became a food blogger, regaling his 450,000 plus Instagram followers with the latest trends in food, wine, and beverages, indispensable kitchen products, restaurant reviews, and healthy recipes. Yet recently, the pressure of negotiating product placement deals with corporate sponsors and restaurants while keeping his followers up to date has resulted in his casual cocaine use to become more of a problem. Fresh from a 30-day stay in rehab, Mr. Crady embarked on a celebratory trip to California to visit his family. While traveling through the entryway of the football stadium on February 15, 2019, he was injured when a portion of the ceiling collapsed, striking him on the head. The structure had been constructed in 2017 by the Rams Construction and Maintenance Company, a company located in Los Angeles, which has also maintained the structure since its construction. Mr. Crady was hospitalized for 3 days and was diagnosed with a linear skull fracture. He has since complained of the inability to concentrate properly and being unable to smell and taste his food as he did before the accident. He has also become quite irritable and has difficulty getting along with other people. Mr. Crady has filed suit against the Rams Construction and Maintenance Company, Incorporated, for his personal injuries and special damages.
For speed purposes, obviously, we are going to conduct a very constricted voir dire time-wise, and so I am going to ask my questions for the most part, of the group of jurors, and then go down to individual jurors when we get certain responses. But let's start out. Good afternoon, ladies and gentlemen of the jury. My name is Robert Kellner, and I represent a gentleman named Tom Crady, who is bringing a lawsuit against the Rams Construction and Maintenance Company as a result of an accident that happened on February 15, 2019, when my client was going into the Rams stadium and the ceiling collapsed on him. And we are not going to discuss great details of the injuries right now. The purpose right now is to talk to all of you to see whether this is the kind of case where you would feel that you could sit fairly as a juror, and where both I and the attorney for the Rams Construction Company and Maintenance Company could do the same. And I would now like to introduce to you the attorney for the defendant, the Rams Construction and Maintenance Company, Karen Campbell. Do any of you first know either myself or Karen Campbell, the attorneys on this case? Okay. Did someone answer?
I said no.
Okay. So the next question is Tom Crady, by the way. Maybe some of you have seen him either on The Bachelor or The Apprentice, or follow his food blog, which is followed by 450,000 people, and it could be one of you. And the defendant in the case is the Rams Construction and Maintenance Company. They built the stadium in Los Angeles. This is not the Rams that we are suing. So if we have specific football fans that either love or hate the Rams, I hope that that won't be important to anyone here. But do any of you know either Tom Crady or the Rams Construction and Maintenance Company? No. Okay, good. Then hopefully we are starting out even. Do any of you watch The Bachelor or The Apprentice on television? Any of the jurors? No one watches either of those shows.
Yes, I do. As an entertainment lawyer, I represent a lot of influencers. So, I try to get them placements on great shows, and not really a fan of The Apprentice, but I do watch a lot of reality because they're trying to get their foot in the door.
Okay. That's Ms. Parker, correct?
That's correct.
It is nice to meet you on behalf of myself and Ms. Campbell. You don't happen to remember in watching either of these shows seeing a gentleman named Tom Crady, right? Crady.
No, but I'm familiar with him on his blog because, again, I represent influencers, so I'm always scouring the internet. So I've seen him come across a couple of pages that I've seen regarding his food escapades. Okay. So I am familiar with him. I don't know him personally.
Okay. So let me ask you this. On behalf of Mr. Crady and on behalf of everyone in the case, did you have any feelings, either positive or negative, about Mr. Crady as a result of the food blog?
I thought he was handsome, but some of his opinions about different dishes I didn't agree with. I thought he kind of had a poor taste in food, but I don't hold it against him personally. I'm sure he's a great person, great man. But those are my opinions.
Okay, so when you say you had some thoughts on his opinions, I think I might have different questions for you if you didn't like his salad dressing versus didn't like his political view, if there were any political view that ever was expressed, or any other life views other than his salad dressing, for example. Do you remember what it was that could you explain a little what it was that you're talking about?
Sure, it was definitely food. I think he traveled somewhere and tasted a soul food dish. And, my mother has made this dish forever. And he said it was terrible. And why do people eat this? It's fattening. And so it was strictly related to food. I'm not even familiar with what his political ideologies are. But I didn't appreciate that because it's a great dish. So mainly just food.
Okay. So, on your word of honor, which I think is more important than your oath, tell me, if you were Robert Kellner questioning Holly Parker and you knew absolutely how she felt about what you just said, would Holly Parker be the right juror for this case? Or do you think maybe she would be better off on a different one?
I am confident I will be the right juror on this case. With my legal background and my open mind, I know what my duties and obligations are, and I will not let anything come in to affect that. So I absolutely belong on this jury.
So if he felt that a fabulous food was fattening, is there any chance in your mind that you might ever so slightly bend against him because of that statement, where nothing can be more precious to many of us than our mothers?
I can put it aside. He has to taste my mother's dish and he'll change his mind if I ever get a chance to meet him. So that will not factor in my decision on serving on this jury.
Word of honor?
Word of honor.
Okay. Anybody else know Mr. Crady or the Rams Construction Company? Fine. How many of you have ever sat on a jury before, whether it's civil or criminal? Could I hear from those of you who have been jurors on other cases before?
I was a juror one time.
Okay, that is Mr. Bergman.
I was also
about it. I'm sorry, Miss Lawson too.
Yes.
Tell us, what kind of cases were you on? Were they civil or criminal?
It was a criminal case.
And did that case go to a conclusion?
Yes, we found the defendant guilty.
Okay. We're not asking what the result was, just whether it went to a conclusion. Remember when the judge told you beyond a reasonable doubt at the end of the case? I don't think there'll be any dispute that the burden of proof is different in a civil case than a criminal case, but all I ask you is there anything that happened in that case that would affect your ability to listen to the evidence in this case and listen to the law as the judge gives it to you in this case, and judge us by what we're about, not about the other case? Or is there something there that would affect your ability to sit on this one?
I don't think it would affect my ability to sit on this jury.
Totally different case, right?
Yes.
Ms. Lawson, what about you?
It was a civil matter. Actually, it was a traffic dispute.
It was a traffic dispute. And was that a case that went to a jury or to a verdict, or was it resolved?
You know, it did not go to verdict. It ended up settling.
And did you get to hear proof on the case?
I did. It was an interesting case. I thought the amount requested was kind of interesting, but didn't. At the end of the day, didn't get to make a decision on the case.
So you were there champing at the bit, ready to render your verdict, and they took it away from you.
You know what? Actually, I was. I didn't mind at all. I was kind of busy, so it was fine. But I did have an opinion and would have expressed it.
Okay. So anything in that case that would affect you in this one?
No.
Okay. Anybody else ever sat on a jury before? Fine. What I would like to know now is how many of you or any members of your family or even close friends have ever sued or been sued in any kind of a personal injury case? Anybody? Ms. Lawson, your hand went up a little.
Well, I have a friend who was sued. They got into actually a fight at a bar, and there was quite a brawl that happened. And my friend was sued. It was kind of a ridiculous case. They wanted all this money over really kind of minor injuries, as far as I could tell. So it was, I don't know how it got resolved, but yeah, a friend of mine got quite upset.
There was a case that was a personal injury case.
Yeah.
And you felt that it never should have been brought, or was minor, or just you had a bad thing on that.
It just seemed silly. I mean, you know, who sues after getting into a fight? So it just seemed a little silly.
Okay, so let's just talk about cases in general. What are your thoughts on people bringing personal injury cases? Just generally.
Well, if there's real injury, then sure, that makes sense. I guess the question really is whether there's real injury or if people are bringing suit just to bring suit.
You think there are too many of those that may fit the category that you're talking about?
I'm sure that it really depends upon the case, but I imagine that you hear all kinds of stories and everyone's worried about being sued. So yes, it's an issue.
So you have heard a lot of stories about personal injury cases that have bothered you.
It's probably, like I said, I only had a colleague who was sued that I described, but you just get this sense that there are suits brought out there that probably don't need to be brought.
Okay, I will say to everyone that I don't want to take a huge amount of time right now because we are limited, but in New York, we have a right to ask a juror to step out of the jury and go outside the room with counsel and that juror so that we don't poison the rest of the panel. And I would very much welcome a conversation with Ms. Lawson to more deeply probe some of the views that she has just expressed. But for the sake of this program, we won't. Thank you, Ms. Lawson. I appreciate your answers. Anyone else here ever sued or been sued in any kind of personal injury case? Is that Mr. Abramson?
Yes.
Thank you. Tell us about it, please.
Well, being in the construction industry, I have many colleagues who are injured in the line of their course of their employment. And, you know, within their normal routine, they come across many endeavors where they result in injury because of negligence upon a contractor or whatever. And, you know, injuries are injuries, accidents are accidents, and sometimes they're big and sometimes they're not. So, you know, it depends on the case, like Miss Lawson was saying. It's a case-by-case basis.
I see that you're an electrician. Are you a member of the Electricians Union here in New York?
Yes, I'm a local 3 electrician.
Oh, so I will say to the to the audience, a prayer has just been answered. Mr. Abrahamson is going to be probably very much aware of my favorite statute in the world, which is an absolute liability statute called Section 240 of the Labor Law. And there is no reason for me to ask a lot of questions of him in this particular case. Thank you so much, Mr. Abramson.
You're welcome.
Okay, anybody else have any personal injury cases? Anyone close to anyone? Anybody in that category? Okay. Are any of you or any members of your family?
Bob, you miss Miss Macaulay, the policewoman.
She didn't show up on my screen. Thank you. Ms. Macaulay, can you tell us your situation, please?
Sure. When I was in college, I got into a car accident. Somebody hit me and I was injured. I tore my rotator cuff and some other injuries to my neck and back. And there was a lawsuit to get all of my medical costs covered. But we never went to court or anything like that.
So it was settled out of court.
Yeah.
And in terms of the system, was there anything that, you know, where it rubbed you the wrong way, or were you satisfied with the result?
I was satisfied. I didn't really know why there needed to be a lawsuit. I thought they should have just paid for all of my injuries, my lost work.
We would step outside right now because she is saying some things that I think are terrible, and I wouldn't want her to do that. So we're now outside the room. What were you saying, Ms. Macaulay?
Oh, I just didn't see why we had to go to court. I thought the insurance company should have just paid, because I was injured and my car was totaled and I missed work. And I didn't understand why they didn't just pay. I didn't understand why we had to have a lawsuit. Okay,
thank you. And I see that you're a police officer, so we'll call you Officer Macaulay. Thank you.
Sure.
Okay, so there was resentment, I guess, against the system, Officer Macaulay, with what occurred with you, right? Some.
I wouldn't say I resent it because I think it ended out fine. It just seemed like it was a little more complicated than it needed to be.
And so is that something that could conceivably affect you in this case because you felt that the system did not work right involving a personal injury case? Could it possibly enter into your mind in this case?
I don't think so. I think I could listen to the instructions from the judge and make a decision. I was really young. I was 21 and I hadn't really had any life experience. So in the big picture, the inconvenience from back then is pretty small.
Okay, thank you. And Karen, if you see someone come up on the screen and I don't, let me know and I'll do the same.
Will do. That's exactly what I would. We were in a room together.
Thank you. Okay. So are any of you members of the jury or members of your family either stockholders or employees of any liability insurance company? Any of all of you? No. Okay. Do all of you believe, or do some of you not believe, it is your right to feel any way that you want, that if a person is injured as a result of the fault of another party, that the injured person should have a right to come to court, and if they prove their case, to be compensated? That clearly is the law, but is there anyone here who disagrees with that law? I guess the answer is no to that. If there is a small injury and the plaintiff proves their case, would we all agree that the amount awarded should be small? And I want to question you individually on this question. And let's start with some of the people that we haven't questioned yet. Mr. Miller, if the damages in the case are very, very large, is there anything in your makeup, in your psychology, which would prevent you from awarding a very large amount if that's what the evidence called for? Or do you feel just, I don't want to give a big verdict. I don't like that. Mr. Miller, what about you?
I think the case would need to be decided based on the evidence. If the injury is large, I think the award should be large.
So you are going to hear testimony from doctors and an economist in this case with regard to the damages. If the number at the end of this case added up to be a large number, anything in your psychology, your philosophy, that would prevent you from awarding a large amount if that's what you felt was justified?
No.
No problem. Decide the case on the evidence, right?
Correct, yes.
Mr. Kalin, we haven't spoken to you. How do you feel about that one?
I'm a little concerned about really, really high numbers.
Okay, when you say probably I would step outside with this one, when you say you're concerned about high numbers, what are you saying?
I'm saying millions of dollars, for a lot of things don't make that much sense to me.
So if for some reason in a case, someone had damages that actually totaled in the millions of dollars, would you be reluctant to award that if that's what the evidence showed? Would there be reluctance on that?
If I believed the evidence, I would go along, but I might question it in my mind a couple of times first.
But would you be hesitant to do that, even if the evidence did show that? Would that just be something that you wouldn't want to do? And we can only, rely on your honor at this point.
I'd say it's hard to say without an example, but I can't see for a lot of cases going into the millions and millions of dollars.
And so would it be fair to say that if the number, and again, I want to try to do this quickly, if the number added up to a large number, that you'd be hesitant to do that, regardless of the evidence, you'd be hesitant to make that kind of award?
Well, listen, I'm a working man. I work for a living. I never see millions of dollars. I have to wait and see.
Okay. Thank you. Let's talk to Mr. Bergman. How do you feel about that issue?
I'll whatever the case allows for in terms of damages. I'll do what I think is fair. I don't think there's a number that's too high or too low. It's whatever the case really calls for.
Okay. Mr. Abramson, how about you on that?
I have to share Mr. Callan's opinions on that. I work hard, and I would be reluctant to just give away millions of dollars. I would have to have strong evidence in support of that before I made my decision.
So that would be a rough thing to accomplish with you, right?
I wouldn't say rough. It would have to be solid evidence in support to award multi-million-dollar verdicts.
Okay, it looks like you've been working too long at Lewis Brisbois, but I won't say that for the sake of the program. Ms. Parker, what about you?
Well, as an attorney, I forgot to mention this earlier, but I didn't actually pursue the lawsuit or litigate the case, but one of my clients was performing and slipped and fell on stage. And I, know a lot of people in the industry, so I had to refer the case out. And the case went to trial, actually, and the client got awarded a really small amount. And the jury didn't even consider, the damage to her reputation, that she was embarrassed. This was on live TV. And, I just didn't think the verdict matched, what my client went through. Granted, she had a scrape on her knee and they put a Band-Aid on it. But she was embarrassed. She was humiliated. I couldn't even negotiate any deals for her after that. And I didn't think it was fair. So that's my opinion.
Okay. And you're an attorney, and that has nothing to do with what you would do in this case. Fair statement?
Fair statement.
Thank you. Ms. Lawson, what about you?
Yes, I could. I'd be willing to consider the evidence. Certainly, I prepare evaluations, constantly in my job. So, it's got to make sense.
Got to make sense.
Yes.
What kind of evaluations? I see that we're going to talk about your occupation in a moment, but I see that you're an investment banker. What kind of evaluations do you do?
Valuations. Well, certainly what I do is I help buy and sell companies. And part of what I do is I prepare financial models. I prepare or obtain valuations. So the numbers, they matter. If someone comes up with a number, it has to have support behind it.
Of course. And as an investment banker, by the way, do you own stock in any liability insurance company, or do you do any work with them in terms of financing your purchases?
I thought about your question when you asked if anyone had, I don't know if anyone I know has stock in insurance companies, but I guess it could be possible. I do not have any stock in particular, of which I'm aware, in any insurance company. We have dealt with insurance companies over the years.
And do you work with them in financing your corporate purchases, as in terms of putting together the financing for businesses you'd buy?
Usually dealing with private equity firms, banks, sources of financing, not insurance companies necessarily.
So they're not, when you say necessarily, are they a portion of the pool of capital that would be used to purchase?
At times, could be.
At times they would be.
Yes.
So which companies are in that group?
I'd have to go through, I'd have to look. We've had a lot of transactions up until now. So I don't conceivably a number of the casualty companies would be in that group, right? It could be.
Okay, think about that. I'm going to come back to you in a little while, but thank you for bringing that up to us. So does anybody here, any of you, know anyone that has ever had a fractured skull or any other type of head injury? Any members of the jury know anyone that has been in that category? Okay. Next question.
Have Belinda, please.
Yeah, I do. Sorry.
Okay, could you tell us about that?
I'm a police officer and have been for 24 years. And I will fairly regularly encounter people in the course of patrols and investigations that have head injuries. Sometimes they come into the criminal justice system because of some of the impulse control and other issues related to their injuries.
So what you're talking about is that people that have been the victims of crime have suffered head injuries of various types. And I assume you're talking about the victims that you see.
It's not always criminal victims. It's just that sometimes people who have head injuries are, especially really serious head injuries, I end up encountering them because they have issues with memory or impulse control. And so a lot of the people I see frequently, have that type of injury.
Okay, thank you. This is something which I want to put out on the table and talk to all of you about. My client, unrelated to this accident, and my client before this accident occurred, in part due to the stress of his job and in part just due to all kinds of other things, unfortunately developed a cocaine problem. And he went into rehabilitation. It had nothing to do with the ceiling, but is an issue that will come up in this case. It is something that he is glad is behind him, and he went through rehab, but there are a lot of people that will react with regard to that. So I'm going to ask each of you individually. My client had a cocaine problem. Let's start with juror number 7, Ms. Parker. Do you feel that I should close up my briefcase and go home, or do you feel that you would be interested in seeing whether this has anything to do with the case and not be prejudiced against him? Ms. Parker, how do you feel about that?
Well, this brings back, a pretty sour memory. I had a client, negotiated this incredible deal, this multi-million-dollar deal. And right before they were supposed to perform, they did a bump in the dressing room and totally blew the deal. I had to sue the company because they wouldn't pay us because my client was just totally out of it. And, it just, I had to refi my home. It was just, I was banking on this deal and he just blew it. So every time I hear the word cocaine, it drives me nuts. But I think I can be fair. I will do my best to be fair. It's the best I can give you.
So if you were Robert Kellner and you represented Tom Crady, would Holly Parker be a juror that you think should be on this jury or not?
I have evolved, I would think. It just brings back bad memories. But I will give you my word that I will keep an open mind and I won't hold it against your client in this case.
Bob, I think we have 1 more minute for you.
I'm going to finish with this very quickly. Any of the rest of you feel that you'd be prejudiced against him because of the cocaine? Okay, I just would like to ask each of you what your occupation is and whether you're married or single and what your or significant other and what your partner does. Ms. McCauley?
I'm a police officer with the Beverly Hills Police Department. My husband is in building products.
Mr. Abrahamson?
I am a journeyman electrician with Local 3, and my wife is a paraprofessional in the New York City Department of Education, and I have 2 children.
Thank you. Mr. Bergman?
I'm a classical trombonist. I play with different orchestras around the state, and my wife is a music teacher. No children.
Thank you. Ms. Lawson?
I'm an investment banker, and my spouse is a marketing executive.
Mr. Kalin?
I'm a postal worker and my wife is a lawyer.
What kind of attorney is she?
A good one.
In what field of practice?
She works for a legal association.
Okay, thank you. Mr. Miller?
I have been working as a bartender / mixologist since returning from service in the Peace Corps, and I am single.
Ms. Parker?
I am single. I'm an entertainment lawyer. As I mentioned, I represent influencers and I will sue if I have to in the entertainment realm. So I do both transactional and litigation, and I'm happily single. No children.
Thank you. Will each of you be fair and impartial jurors and decide this case the way you'd want it decided if you were any of the litigants in this case? Karen, all yours.
Good afternoon, potential jurors. My name is Karen Campbell again. I'm with the law firm of Lewis Brisbois, and I represent the Rams Construction and Maintenance Company. I'm happy to be here with you today. The first thing I want to ask everyone by a show of hands, and please tell me, is there anyone who, as you sit here right now, based on what you've just heard, believe that my client has done something wrong? Mr. Kalin, I see you raised your hand. Based on what you've heard so far, you believe that my client has done something wrong?
Well, looks like something wrong has happened. I'm not sure about your client, either one of them.
Do you believe that there are accidents that can happen that are no one's fault?
I do believe that could happen.
Okay, so let me ask you, if you were selected as a juror on this case, would you keep an open mind and listen to both the direct and cross examinations before you made up your mind about what any particular witness has testified to?
Yes, of course.
Okay, and would you keep an open mind listening to the arguments of the defense before you make up your mind as to what the case is about?
Yes, I would.
Okay, I ask you that because I'm defense counsel, and for the most part, I'm always going to go second until the very end of the trial. And so I need to know that you're not coming in with an already made up mind, that you're going to listen to the cross examinations, you're going to listen to the defense case if the defense chooses to put a case on, and then only after you've heard all the evidence, you'll make up your mind. Is that where you stand right now?
I'm actually a great listener. I spend a lot of my time not talking to anyone, not hearing from anyone. So I do a lot of listening.
Okay. So if I were to ask you if Mr. Kellner was, a foot ahead of me and I'm a foot behind now, or whether we're equal at the starting line, what would your answer be?
I haven't heard everybody yet.
Okay. So basically we're starting on the same footing. Is that what you're telling me?
That is what I'm telling you.
Okay, thank you. I ask this, jurors, because this really is a self-selection process. Only you can tell us various things about yourself and your viewpoints that would enable us to know whether we believe this is a great jury for you to sit on. For example, if this was a motor vehicle accident, which it isn't, and you had just been in a motor vehicle accident this weekend, then maybe this wouldn't be the case for you to sit on. So there's no right or wrong answers. There's just the answers that you want to give us so that you can think through whether you think you're going to be a great or good juror on this case, and so that we can make decisions along those lines as well. Does everybody understand that? Okay. Who in this pool has had situations where you've had to make decisions based on conflicting information? I know, Mr. Abrahamson, you said you have 2 children, right? Are there ever occasions where something happens and they both come to you and tell you a slightly different version of what took place?
Oh, always.
Okay. And how do you resolve that?
Go to the wife.
Okay. You don't know either child in this case, and you're not going to have your wife to rely upon. So you're not going to be able to say, well, little Johnny usually colors things, and, you know, little Janie usually is very blunt and tells the truth. You're going to have to look at the witness who's on the stand and make a decision based on their characteristics, how they answer questions on the stand, what they say, and how that information sits with other witnesses that you're going to hear. Will those types of things help you make a decision on what you believe took place in this case?
Listening to the evidence, yes.
Okay.
The totality of it.
What about in the job field? Have you ever had anything that happened on the job where two of your coworkers have had different versions of something that's taken place?
All the time.
Okay. And how do you resolve it with them? And you can't go to your wife?
You try to listen and try to decipher who has the most credible story based upon what's transpired.
That's true. A lot of times jurors wonder, particularly if this is their first time, and I know we have a couple of people who have served on juries before, they wonder like, oh, this is some magic thing. What's going to happen? What do I do? You're going to do something that you do in your everyday life, which is listening to conflicting stories or information and make a determination based on what you find credible, based on everything that you hear and everything that you know. Because even though you're coming in as a juror on this case and you don't know anything about the case, you're going to come in hopefully with an open mind, but that doesn't mean that it's an empty mind. You have life experiences and things that you're going to be able to draw on in terms of evaluating the evidence as you listen to it. Is there anybody who thinks that they're going to have a problem doing that?
Have to do it every day.
Yes, Officer McCauley. So with that, you'll be able to evaluate contradictory evidence?
Yes, that's at least several times a day I have to do that. So I think I'd be comfortable doing that.
So there are going to be some experts that testify that are doctors and maybe experts in other disciplines. The fact that they're an expert, will you hold their testimony to any greater weight than you would a regular person?
No.
Okay, and why is that?
Well, I think you have to assess somebody's credibility based on all the same factors, no matter what they do for a living. I mean, I'm sure there are experts who know more about, anything than I do, but I still think there's a way for somebody who's super knowledgeable to not be particularly credible when they're telling, a certain version of events.
Okay. And is there, do you think you'd have any problems in this case looking a little deeper into the evidence and listening to everything before you make up your mind?
No, I think you have to do that as a juror. That's your duty.
Ms. Lawson, you were asked about lawsuits and you talked about, a friend who had a lawsuit brought against him or her. With regard to that, you understand and believe that people do have a right to sue. Is that correct?
Yes, I do think people have a right to sue.
And in that same regard, do you also believe that people who have been sued have a right to defend against a lawsuit?
Well, yes, absolutely.
Okay, because you understand, like you could go home tonight and your neighbor could say that you scratched their car and start a lawsuit. So you would have the right to defend yourself, correct?
Of course.
Okay. Is there anybody who feels like a defendant in a case doesn't have a right to defend themselves in a litigation? I don't see any hands. Okay. I represent a corporation, and Mr. Crady is a person. Is there anybody who feels like because he's a person and the defendant is a corporation that you're not starting off on an even footing in listening to this case? Mr. Abrahamson, you recognize that the corporation is made up of individuals who go to work every day and try to do their jobs, right?
Correct.
Okay. And so will you listen to the evidence about what took place with the ceiling or did not take place with the ceiling before you make a decision as to whether or not my client has done something wrong?
I'll listen to the evidence, yes.
Have you ever worked on a large construction project, or do you mostly go into homes and deal with jobs that are in a residential setting?
Both.
Right. What percentage of your work has been on large construction projects?
65% or so.
And have you had good experiences working on those types of projects?
Some yes, some no.
Is there anything about that experience that you think would make it difficult for you to serve as a juror in this particular case?
No.
Will you be able to set aside your experiences and base your decision in this case based on the evidence, the witnesses, the documents, the photographs, the things that you see in this particular case?
I will base my opinions on the credible evidence.
Thank you, Mr. Abrahamson. Someone mentioned that they had been sued. I'm sorry, who was that?
I think my lawyer had to sue somebody, but I wasn't sued myself.
Okay. And your lawyer sued on your behalf?
Yes.
Okay. So were you the plaintiff in the lawsuit?
Yes.
Okay. Is there anything about your experience as a plaintiff in a lawsuit that you feel Officer McCauley will make you identify with the plaintiff in this case?
No, it was a completely different type of situation.
Different situation, different injuries, different everything. Is that correct?
Yeah, very, very different.
Okay. And so you won't be, while you're listening to evidence or deliberating and trying to make a decision, using what transpired in your case in order to help you make a decision in this case. Is that right?
That's right. That case was really short anyway, and it didn't go to trial. So there's really nothing that's similar.
Ms. McCauley, in this particular case, if the plaintiff doesn't prove his case, would you have a problem saying that at the end of the case?
No, not at all. I mean, that happens all the time in my job too. So, there's legal standards you have to adhere to.
And we really can't get into legal standards, but there's something called the burden of proof, which the judge will instruct you on at some point during the litigation. But I'm going to say to you, it's something like, and I don't always know why I use this example because I'm not a cook, but if you're making a cake, you need flour, you need butter, and you need eggs. Basically, the plaintiff has to prove he has flour, butter, and eggs. And if he doesn't have eggs, he doesn't have a cake. And if he doesn't have a cake, he doesn't have a cake. Is that correct?
Yeah, I only cook from a box, but yes.
Okay. Anybody have any problem with if he doesn't have all the ingredients and elements that you're going to hear about from the judge, that if he doesn't meet that criteria, that you can send the plaintiff home with no money? Ms. Parker, what about you?
Just thinking back to that case where I had to refer my client out to someone, and the injury was small. It wasn't her fault that she slipped on the stage, and it was a big corporation that the case was against, and they barely awarded her anything. I think the cost of a box of Band-Aids and maybe a dinner or something. I keep an open mind, but it just seems like even if all the elements are there, sometimes they're ignored or there's not enough emphasis. And I guess it depends on who's trying the case or defending, but I just go back to that. It was just really disappointing. But I do believe, like you said, all the ingredients need to be there to make a cake. And in that case, I thought it was. The result was.
But were you in court every day during your friend's case?
Not every day, no.
Okay. Were you there any of the days?
I think I was there for opening, for the client's direct. where she was questioned. And then I was there for a portion of the closing just to see how everything wrapped up.
Okay. So you realize that you weren't there to hear all the evidence in that case, correct?
I do.
Okay. And so maybe things took place in that case that you were aware of the big picture, but you weren't aware of all the small details. Could you agree with me that that's fair?
That's fair.
Okay. So could you set that aside? Because if you're in this particular case, you're going to hear all the details. You're going to be here not for just portions of it. You're going to hear everything from soup to nuts. And you may find all the ingredients are there. You may find that all the ingredients are not there. Is that going to be something that you feel like you're able to do?
Absolutely.
Okay. You're not going to try to right any wrong on your friend's behalf if you're a juror in this case, right?
No, but if the facts support that, the guy was his reputation or something, and there's evidence to support it, I will strongly consider that. But I won't just make up something out of air and just rule in his favor just because of my prior experience with my client.
Okay. And just to ask you this, you're a lawyer, and Mr. Crady was a practicing lawyer at one point. Is there anything about his prior profession that would make you lean more towards his side of the case than towards maybe the defense side of the case?
No, most of my friends are non-lawyers, so I only have a handful of lawyer friends there. So I totally respect his decision to change his profession. Right.
But because he's a lawyer, you're not going to find him more credible than anybody else, right?
No, not at all.
Okay. By the way, I think you said that you do a lot of entertainment law. You watch a lot of reality TV, right?
That's correct.
Okay. And did you say that you'd seen Mr. Crady on either The Apprentice or on The Bachelor?
No, I saw some of his blogs. I think he blogged about food or something like that. So in keeping up with my clients, I kind of look at Instagram and everything, YouTube, and I came across a couple of his posts or videos or what have you.
But
so
you don't know him from reality TV, right?
Not at all. No.
Okay. Would you agree with me that reality TV isn't always reality?
Absolutely.
Okay. Some of those shows like Survivor and Big Brother are about deception, outplaying, outwitting, and things like that aren't necessarily real life, correct?
Absolutely. And it brings in good money, but yeah, you got to kind of make it interesting sometimes.
But it can be real life where people are trying to outplay and outwit. Will you agree with that? Okay.
I agree. Yeah.
Okay. Does anybody on the jury, Mr. Bergman, for example, let me ask you this. Do you have any kind of social media, Instagram, social media, Facebook that's related to your work as a musician?
I do use Facebook and Instagram. I should use it more for my work, but I really don't. So I don't really have too much of a work presence there. It's mostly for just social purposes. But I do have a website that I use for work purposes.
And have you ever had any negative experiences with social media, bad reviews, things of that nature?
Because I really use it more for personal and not for work, I really haven't, because generally speaking, the general public and my employers don't really know my social accounts. It's really just for friends and family.
So the fact that Mr. Grady has a big Instagram following and what he does in terms of his work, is that going to have any impact on you in listening to the facts in this case?
No, I've never heard of him before. It won't affect me at all.
Okay. Mr. Miller, you're a bartender. And I'd like to ask you, Mr. Kellner has brought up that Mr. Grady had a cocaine issue. Anything about that? Like, do you know anyone, any friends or family or anyone that you know who's had a similar issue?
Yeah, so I think I can reserve my judgment when listening to, that kind of issue described, but I have had a family member or two who have struggled with substance abuse, so it might get a little uncomfortable at times.
Okay. It's the fact that substance abuse is going to come up in this case. Do you think that it's a case that you can be on and evaluate the evidence fairly? Or do you think the fact that you know people who have struggled with substance abuse, do you think that that's going to be an issue for you?
I don't think personally that it's going to cloud my judgment in this case.
Would you be able to listen to the evidence regarding whether or not that substance abuse actually started before this accident?
Yes.
Okay. And would you be able to evaluate that evidence, see if any of the alleged injuries are related to that substance abuse?
Yes, I am curious to hear if there is any connection between the cocaine use and the injuries, but I can keep an open mind and listen before.
What about you, Mr. Bergman? You're a musician. Do you know anyone, worked with anyone who's had a substance abuse problem?
Yeah, my industry, unfortunately, a lot of people do have substance abuse problems. I don't judge people for that. Everyone's got their own personal struggle. And I don't think it really affects anything in this kind of case.
Okay. I'm going to ask you because, we're humans. And when we hear a person has a struggle or we hear a problem, a lot of times we're either concerned or we're sympathetic. But you realize that in a court of law, you have to set aside your sympathy and your concern for another human and decide the case based strictly on the evidence that comes from the witness testimony, the documents that the judge lets in, photographs that the judge may let in, and the like. Would you be able to do that in this case, knowing people who have had substance abuse problems?
Yes, I would.
Is there
Okay.
anybody?
I think we have to wrap up this so we can go to the California lawyers.
Okay, well, let me just ask one last question of everybody before I stop talking. Mr. Kellner has mentioned that, or talked about damages and maybe the type of money that may be asked for at the end of the lawsuit. To save time, I would ask everyone normally, but I'm just going to ask you as a group. If the plaintiff fails to prove his case, he doesn't have the eggs, so he doesn't have a cake, would you be able to send him home with zero award? Is there anybody who feels they're unable to do that?
I don't know at this juncture.
Okay.
Not ready to say.
So you're saying that there may be an instance where you don't believe that necessarily my client has done something wrong, or he has proved that, or he's proved that his injuries are related to his allegations, but you may still award him money in the case. Is that what you're saying, Ms. Lawson?
I would keep an open mind. The way you all described the case, it seemed that he had a head injury that he suffered there, from the building. But if you're able to present that that's not the case, I have an open mind.
Okay, very well. Is there anything that we haven't asked you that you think that we should know before I sit down and stop talking that'll affect your ability to be a juror? Anyone? Thank you very much. I appreciate your time.
Okay, at this point, I think that what we should do, Barry, do you want to have the vote from the audience at the end, and Karen and I will just let them know what we would do with our challenges?
I think we need to have the jurors questioned by the California lawyers now, and then we'll do the voting because we're running out of time.
Okay, I think in 2 minutes we can just say what we would do. The jurors that I would challenge are juror number 1, Belinda McCauley, who is a police officer, which is the only stereotype that I ever follow. And I would challenge juror number 4, LaVon Lawson, the investment banker, if we didn't get her off for cause. There are other jurors like Mr. Abramson and Mr. Kalin that are terrible on damages, but I don't want to spend my third challenge on them. And Ms. Parker is certainly an extremely unusual juror, but I would not challenge her on this particular case. Karen?
I think that while I normally would think the electrician being in the construction industry may favor my side of the case based on some of his answers, although he did say he needs strong evidence for a high verdict. I'm not quite sure about the electrician in this case. I'm not sure about the postal worker, although I'm not sure about the postal worker. And I haven't had enough time to kind of think through everything because I didn't take any notes while I was talking. But I think that I would think in my mind that I could work with the investment banker. I could work with the attorney. They would probably be analytical and they know the value of money. So I would probably not challenge them. And the musician and bartender, I'd have to think about a little bit more. But there was I don't think anything that they said today that jumped out at me that made them seem on their face bad jurors. And I would include that for the police officer as well.
Okay, Barry, all yours.
Okay, so now we're going to turn the program over to the California side and see how they would handle a jury voir dire.
Okay, so in California, we do a mini opening statement. So that's supposed to be as short in a regular case, 3 to 5 minutes. We're going to cut it down. I'll go first, then Paul will go first and give the defense opening. Then we're going to go right into the questioning. The questioning in California is first done by a judge or jury questionnaire. So many of the questions that were asked, occupation, significant other, children, prior lawsuits, prior jury service, any injuries or people in same or similar circumstances, those questions would already be asked. So then we're going to proceed. And so I'll do my mini opening. Paul will do his. I will then question for about 20 minutes. Then Paul will question, and then we'll wrap up and tell you what we were going to do. So please, the court, counsel. My name is Brian Panish. I represent Tom Crady, a 40-year-old gentleman who is a former United States prosecutor for the federal government. He left the law, thought about a career in politics or maybe writing, but decided not to and entered a different career, quite different, in the food industry. He became a critic, he became a blogger, and he wrote about his passion of food. He had 450,000 followers on Instagram. He was very big in the food, wine, beverage, indispensable kitchen appliances, and things like that. He wrote recipes, healthy recipes, and restaurant reviews. For whatever reason, whether it was leaving the law or his job, he developed an issue with the use of cocaine. As a result of that, and I'm telling you this to be upfront about everything, he spent 30 days in a rehabilitation. He had resolved his problems. He then was traveling to California for a celebratory to visit some people, friends. He went to a football game at the stadium where the Ram Construction had built it, owned by the New York Giants. As he's walking at the stadium, a portion of the ceiling collapsed on his head. The structure had been in existence since about 2017. He was taken to the hospital. He remained for 3 days. He was diagnosed by an X-ray with a fractured skull. As a result, now he continues to have headaches, difficulty concentrating, unable to taste and smell food, which was an important part of what he did before. He also becomes quite irritable, has a difficulty getting along with people. You hear that's from the brain injury, the portion of the brain in which he was injured. And in this lawsuit, we seek damages for past and future pain and suffering, medical expenses, and loss of income. And we will be seeking at the end of this case a substantial multi-million-dollar award. Thank you. And we'll go to Paul. He'll get up and go, Paul.
Welcome, ladies and gentlemen. My name is Paul Kiesel. I'm proud to represent the Rams Construction and Maintenance Company. I want to start by saying we're very sorry to what happened to Mr. Crady. We try to build the best buildings that we can, and we certainly don't want to cause injury among any of our guests or other invitees. The fact is, a simple ceiling tile did fall off the ceiling, and it did strike Mr. Crady on the head. Mr. Crady was hospitalized for just to make sure he was okay. There'll be substantial evidence presented in this case regarding the nature and extent of his injuries. While he certainly did suffer an injury when the ceiling tile fell on his head, we believe that reasonable damages here will be a fraction of what the plaintiffs believe are owed. We ask that you listen to the evidence and decide this case on the evidence, and we look forward to speaking with you about this case more.
Okay. Now the judge will turn it over to me and I'll begin. So ladies and gentlemen, I'm going to begin by asking a series of questions with statements and ask you whether you agree or disagree. And we'll just go down the row, starting with Ms. McCauley. And the first question is, do you agree or disagree with the following statement? Most personal injury lawsuits are brought by people who are looking for deep pockets. Raise your hand if everyone that agrees with that statement. I see Mr. Kalin, Mr. Bergman, and Mr. Abramson. Next question. Most people who file personal injury lawsuits for money damages exaggerate the severity of their injuries in a court proceeding like this. Who agrees with that statement? Mr. Abramson, Mr. Kalin, Mr. Bergman, across the board there. That's fine, thank you. How about this statement? The amount of money juries award in personal injury lawsuits is usually excessive. Mr. Kalin, you agree with that?
Not necessarily.
Okay, we'll come back to you. Mr. Abramson, you agree with that?
Somewhat. It depends on the evidence and the severity of the injury.
And how about you, Mr. Bergman?
I think when people bring claims, they probably exaggerate from time to time, but I don't have any reason to believe that the juries give too much money.
Okay, thank you. How about this statement, agree or disagree? Awarding someone too much money in a personal injury lawsuit makes them less motivated to help themselves. Who agrees with that? Raise your hand. I see no hands. Mr. Abramson, you're kind of on the fence. Maybe, maybe not. What are your thoughts on that, sir?
I don't want to say yes. I don't want to say no. It depends. It's if you're using, I guess it depends on their background, what they did prior, the accident, and what their future looks like. If they're embellishing an injury and they're getting a windfall, then there's no motivation to go back to work and be productive.
All right, fair enough. I'll come back with that. How about this statement to everyone? The main reasons lawsuits don't settle out of court is because the person or the people bringing the lawsuit are unreasonable and want too much money. Who agrees with that statement? I don't see, I see Mr. Bergman thinking maybe, fair, Mr. Graham, some people, but not most. Is that what you would say, Mr. Bergman?
I mean, I think it's certainly a possibility in some cases. I don't know if that would be true in this case.
Who thinks that's the case in this case, just based on hearing the mini opening statements? Raise your hand if anyone believes that already. I see no hands on that. All right, let's go now to the next question that I have. And it has two possible answers. And I'm going to read the question first, then I'm going to give you the answers and say who agrees with number one or number two. And here's the question. With regard again to most lawsuits, do you think they are caused by the fact that number one, people who file lawsuits are victims of harmful events, or number two, people who file lawsuits don't want to take responsibility for what happens to them? Most lawsuits filed by people who are victims of a harmful event. Who agrees with that? Raise your hand. Okay, everyone who agrees with this statement. People who file lawsuits don't want to take responsibility for what happens to them. Mr. Abramson, you're saying maybe, right?
Yeah, because even when you file a lawsuit, there's the plaintiff still has the possibility of saying, okay, I'm partially at fault. So I don't think they're going to concede 100%. But based upon Mr. Keisel saying before, it seemed like there's no contestation of here a fault in this case.
Well, let me ask you this, Mr. Abramson.
Yeah.
Based on that, if the evidence warrants a substantial multi-million-dollar verdict and it's supported by the law, will you hesitate for 1 second to award it?
Well, it depends on the credible evidence. You have to bring them.
As my question is, if the evidence supports it, the evidence introduced at trial supports a multi-million-dollar verdict, are you going to hesitate even for a minute to do that?
It would depend on the evidence.
So you're hesitating. So I'm already asking you to assume, sir, and that's fair. That's why I want you to be honest. So you would agree with me that if the evidence overwhelmingly suggests a multi-million-dollar verdict, you might hesitate to do it.
I would have to see all of the evidence.
Okay, I'm saying you saw all the evidence. It overwhelmingly supports a multi-million-dollar verdict. Are you going to hesitate to do that? Yes or no?
Based upon your assumptions, I would not hesitate if it warrants.
If you had a loved one or yourself that was seriously injured or killed by the fault of another, would you bring a lawsuit?
Yes.
To the whole panel, if you had you or yourself had a loved one either injured or die, would you bring a lawsuit? Who would bring a lawsuit if you thought someone else was at fault? Okay. Mr. Miller, you seem a little bit on the fence there, sir.
I think the last part is the key, that if I think someone else is at fault, that makes a difference, but it depends on the situation, really.
Okay. Next question, and I'm going to go down the list. I'm going to start with you, Ms. McCauley. Do you believe there should be upper limits or caps, a cap on the amount of money juries are allowed to award in personal injury cases? Who agrees there should be a cap on the amount of money a jury could award? Okay, Mr. Abramson. Anyone else believes there should be a cap or a limit, and that the jury shouldn't just be able to give whatever they think the evidence supports, that they should have some limitations that are preset for the jury? Other than Mr. Abramson, does anyone else agree with that? I see no hands. Let's talk a little bit about the cocaine.
Lawson was raising her hand. You had Lawson.
Oh, thank you, Mr. Kiesel. Okay, Ms. Lawson, can you tell me your thoughts about why you think there should be a cap or a limit on what a jury could award?
Well, I'm just responding to your question. So it just seems that whatever's awarded probably have some relationship to the injury. So
okay, and that's fine, and that's of course what it needs to be. But the question is, do you believe there should be a cap or a limit set that a jury, you can't exceed this on this kind of case, the most you can award is X? Do you think the jury should have those parameters?
I think that there could be parameters. I can't give you any particular parameters, but
why do you believe there should be some parameter?
Because you seem to suggest that if it's completely open, you could end up with just a completely unlimited number.
Well, are you aware? Have you heard of a case where you thought it was an unlimited number that might come to your mind?
No.
Okay. Anyone else? Does anyone else believe that there should be a limit, that the jury should tell the jury, hey, look, this is the most you can award on a case like this? And I don't see everyone on the thing. Okay. Let me go to the cocaine issue that was discussed. Number one, has anyone ever had a negative or painful experience with someone who is using cocaine or had a cocaine addiction? Just raise your hand. I see Ms. McCauley. Could you just tell us briefly about that, Ms. McCauley, then we'll talk to Ms. Parker.
I encounter a lot of drug use in my job, but I don't think it would keep me from being fair. One thing you learn as a police officer is that lots of different people have lots of different issues with lots of different substances.
Well, if you heard that there was no cocaine had anything to do with this incident, would that allow you to have a completely open mind?
Yeah, although I think I'd have an open mind regardless.
Okay,
I'm
fair enough.
assuming experts will tell us what the situation is.
Okay, how about you, Ms. Parker?
I think I can have an open mind. My industry, a lot of entertainers, influencers, dibble and dabble with all kinds of stuff. I had an incident with someone using cocaine that lost a big deal that I had negotiated. It took a lot of time to get booked. You just never know if they've really completely gotten rid of it, even if they go to rehab. I've had to let some clients go because of that. But I mean, this case is different, so I'll keep an open mind.
Well, would you be inclined to give less weight or credibility to the testimony of someone who's had a drug addiction in the past? Would you be inclined or tend to give a little, really make them go a little more to convince you that what they're saying is truthful and credible because they had some substance abuse issues in the past?
I'm not sure. I'll try.
You're struggling with that.
I'll try.
It's hard for you. Would you agree that me
Yeah.
representing an individual who has admitted that he had a cocaine problem, who's got help, but still, if we, as counsel mentioned, if we were in a race and we're starting at the starting line, I would kind of be back a couple steps when the race went off, wouldn't I?
You would.
And I would have a little bit of an uphill battle to convince you that you should believe what my client is saying because of the experiences you've had with drug addiction by clients and others that affected you, that would make it impossible for you to be entirely impartial. Correct?
That's a fair statement. Yes.
Okay. Thank you, Ms. Parker. On that drug issue, anyone else have any negative experiences or problems with that as it relates to this case? I see no hands in what I can see. How about, does anyone other than Miss Parker believe?
Daniel has his hand up.
Oh, okay, Mr. Kalin, go ahead. I'm going to ask you this question first, Mr. Kalin. Would you start off believing that someone, let me back it up. Would you be inclined to give less weight or credibility to testimony of someone who's had a drug addiction issue in the past?
Not on the face of it. I'd have to listen to him. But you described you decided Mr. Crady's having a hard time concentrating. So I wonder if that's all because of a bump on the head or partially because of finishing. I mean, there's ambiguity in my mind if the cocaine didn't have some part in that.
Okay, so as we start the case, without hearing any evidence, and what the lawyer said is not evidence, without hearing any evidence, you will hear evidence that my client had cocaine addiction. There's no dispute at one point in time. With that fact alone, do you start believing that someone bringing a personal injury who's had a drug addiction in the past would be less credible or less likely to be honest in their testimony?
I would not think of it that way. I would think of it, I would be listening more carefully because of that issue.
Right. Because somebody,
but I'd just be listening more carefully because of that issue.
well, let's start off. Hopefully in this case, you listen to all the evidence and give it the same. But in this case, you've already heard that my client had a substance abuse issue. Without getting to the extent of it, that causes you, your antenna, your radar, so to speak, to go up and to say, wow, I really need to listen carefully when that person testifies because they've had this past drug issue, correct?
I would feel, I would describe it differently.
Well, but when I asked the question about the drug addiction, you said I'd have to listen. I'd want to listen much more carefully. Do you remember saying that?
Right.
Okay.
But when I heard that he got hit on the head, I have to focus on that issue also more carefully because I know things don't fall out of the sky for no good reason. So I'm looking more carefully at the factors surrounding the falling piece, and I'm looking at more carefully at the issues that make up the character and the context for the plaintiff.
Well, do you start out believing somebody in a personal injury lawsuit who had a drug addiction in the past is likely to be less credible or less likely not to be honest in their testimony?
Straight answer to that question?
Yes,
That's
sir.
what you're asking me, a straight answer to that question?
Yeah.
The answer is no.
Okay.
I'll listen to it.
Does anyone believe that? Raise your hand. Because someone has had a prior addiction, in bringing a case like this, that they have a tendency to be less credible, exaggerate, or embellish things because of that. Okay. Ms. McCauley, you have your hand. Could you explain that to me, please?
I mean, maybe not exactly what you said, but like if somebody's going to testify about something that happened when they were under the influence, then I'd probably be a little biased about that. But just because they in the past had a bad habit or substance abuse addiction, then I wouldn't hold that against them or think that they were less credible. But yeah, I mean, I've talked to a lot of people who are high and they say a lot of things that aren't true.
Anyone else on that drug addiction issue? I don't see any other hands. How about this game for this part of the case was in Los Angeles. Is anyone here a Rams fan? LA Rams. Okay, Mr. Bergman. The LA Rams are one of the parties in this lawsuit. Are you a pretty big fan?
Big fan.
Okay, you can name the starting quarterback.
Well, let's see.
You're under oath now, Mr. Bergman.
It's Stafford this year, right? So yeah, Stafford.
Very good. So you're all right. Do you know the record this year?
3-0.
Okay, so you're a fan. So we're bringing a case now. This is a case we're bringing.
I still have my golf jersey.
Okay, so you're a long time diehard fan. Couldn't give up the golf jersey even. I bet they give you a good price for that in Detroit right now. But anyway, we're bringing a case against a team that you like and probably as a kid. So were we on that line when we're beginning the race and we're suing the team that you follow, that you die and cheer for? And when they lost that Super Bowl, I'm sure you weren't feeling too good. So are we right at the beginning? Or are we maybe just a little bit behind as we start and we need to catch up in your mind?
Well, look, unless you tell me that this case is going to affect their draft picks, then I'm pretty sure I'm good to go. No problem.
Okay. Very good. Thank you, sir. Anyone else? I see no hands on that issue. Let me go back to these issues.
Actually, I'm a fan of the stadium. So
the SoFi Stadium, you're an architectural person. You're into the design. So
it's nice that it's bringing some interest into the area. They say that stadium's amazing. So
do you think that in any way that will cause us to start a little bit back, have an uphill journey, have to overcome those thoughts you have in this case?
No, I don't think that'll be a problem.
Thank you, ma'am. Does anyone believe that someone could have a brain injury and still appear normal to people who don't know them? Let me say that again. Okay, Ms. Lawson, you understand or you believe that somebody could have a brain injury sitting in the same room. You don't know them. You don't know their personality, but they could look fine to you when in fact they had a significant brain injury.
Yes.
Okay. Anyone else? Does anyone think that if you have a significant brain injury that somebody should be able to see it right away when you're sitting there?
Maybe.
Mr. Bergman, you're like, I don't know, maybe. What do you tell us what you're saying?
I just don't know. I would think that if someone has a significant brain injury that you'd be able to tell, but I don't know.
Okay.
I tend to agree with him, Mr. Panish.
And tell me that, Mr. Abrams. What's your thought?
In terms of if you have a significant, and I use the word significant, I'm sharing your word, that there should be some sort of outward sign of it. I'm not saying, there should be something.
Well, do you think someone that has chronic pain can still appear normal and appear to be able to function that people don't know them?
Yes.
Does anyone not think that somebody that could have chronic pain but appear to be normal and functioning if you don't know them? Or does anyone believe, let's put it the other way, that if you have chronic pain, you should be curled up in a ball or sitting in a chair and everybody should know it? Anybody think that? I don't see any hands on that. Let's go to a little bit about damages. I'm going to ask you this individually now. I'm going to start with Mr. Miller. Mr. Miller, what is your opinion about awarding someone money damages for future loss of earnings in a personal injury case? You're okay with it? You don't see how somebody could be projected out in the future? You don't know if they'd still work? What are your thoughts on that?
I would want to learn more about how you come to conclusions about these projected earnings, but on the surface, I don't think I have a problem with that.
Okay, does anyone have an opinion that would be very difficult to project what somebody could earn in the future, and they would be hesitant to award money damages for future loss of income? Future, that's what you would have earned that you claim you were unable to as a result of this. And I'm not seeing, I don't have everyone on the screen, of course, but I'm going back and forth. How about you, Mr. Kalin? How are you on that future loss of income issue?
I have no problem using that process to determine.
Okay. Fair enough. So I'm going to go, I only have a few more minutes here. I want to ask a few more questions. I'm going to go pretty quickly. I'm going to ask you 2 questions each juror, and then I'll follow up. And I'm going to start with you, Ms. Parker. Ms. Parker, what is your opinion about awarding someone monetary damages for pain, suffering, emotional distress, loss of enjoyment of life, intangible losses like that? Positive or negative?
100% positive.
Mr. Kalin, what is your opinion, positive or negative, about awarding pain, suffering, emotional distress, loss of enjoyment of life damages to someone?
I'm okay with that.
Okay. How about Ms. McCauley?
I think if it's warranted, sure.
Ms. Lawson?
Positive with support.
With supporting evidence.
Yes.
Fair enough. How about you, Mr. Abramson? You're not on my screen, but I know you didn't leave.
No, I agree with the consensus. If the evidence supports it, then it's fine.
No problem. You're positive. If you got the evidence, you're not going to be a problem.
That's correct.
How about you, Mr. Bergman?
Same, not a problem.
All right. Let me go to this last question, and I want to start with you, Mr. Bergman, since you're up. Do you start believing that most claims of emotional distress in personal injury lawsuits are exaggerated?
I don't really have a feeling one way or the other. I'd really just have to hear the testimony.
How about you, Mr. Abramson?
With the words most, is that that's what you?
Yeah, the word was most.
I'd say the majority of them are, but there are legitimate claims, and that's what gets shadowed.
But your mindset as you come here today, based on all your real life experiences, would be
my antenna would
most claims, most, not everyone,
right,
but most, which means more than 50% of emotional distress are exaggerated, correct?
Correct.
Okay. Who else would think like that? Like Ms. McCauley? No. Mr. Kalin, let's talk to you about that, sir. You believe, sir, as you start out here, you haven't heard anything about this case. We just want to know about your mindset that you bring with us today. And you'd agree, Mr. Kalin, in 5 minutes, I'm not going to talk you out of your personal beliefs you've had for many years, right?
Right.
Okay. So I pose this to you, sir. Is it true that you start out believing most claims of emotional distress in personal injury lawsuits are exaggerated?
Yes.
In a personal injury case like this, where we were seeking substantial damages for emotional distress, you would agree with me, would you not, that on that proverbial starting line, with the mindset you bring to this case without hearing any evidence, that we're a little bit back and we got to catch up?
Not necessarily. I'm assuming that that you're all reasonable people and you won't be exaggerating.
But you come here before you've heard anything with the mindset that most of these emotional distress claims are exaggerated, right?
Yes.
And I'm not going to convince you otherwise here in 5 minutes, am I?
Well, when I hear the numbers, I'll get a sense of whether you're one of
We're not
those.
talking
or
about
not one.
numbers. We're just talking about whether someone's exaggerating or not.
Yeah, that's what I
And
mean.
you come to this courtroom with a belief based on your many years of life experience that most people that come to courts just like this and make claims just like our client are exaggerating, correct?
That's right.
Okay, fair enough. Okay, I think I'm probably out of time. And so I appreciate your patience. Please listen to Mr. Kiesel. He'll have questions and then we'll continue on. Thank you all very much.
Thank you.
Let me begin by saying it's certainly possible as jury trials go in the future, this may be the way we do voir dire, where we're looking at each other face to face on a screen and not seeing each other face to face in person. And yet, having said that, we can see a lot of reactions, even facial and hand gestures that are very valuable to take in, even if we're not in the same room with each other. And so let me begin by saying again how much we appreciate your taking the time being here. Mr. Panish covered a lot of the materials already, so I won't repeat much of what he's already done. I can be more targeted in the questioning I'm going to go through with y'all. First question is this. Obviously, the Rams are a sports team. They have a stadium. It's a gorgeous stadium. It took several years to build, and we're very proud of it. Is there anyone who so dislikes the Rams that the fact that that's my client, that no matter what the evidence is, you're going to find against the Rams because you don't like the team? Just be honest, raise your hand. All right, good. So we have no Giants fans in the room, which is helpful. So what we're looking for, folks, is a group of people who can listen to the evidence and base your decision on the evidence you hear in this courtroom. We all come in with biases. We've heard of this expression of implicit bias. We don't even know the biases that we have. But what's important is that you listen to the evidence in this courtroom, and the decision you make is going to be based upon what you hear, the documents you receive, the witnesses who testify. Can you all promise us that you'll wait until all the evidence is in before making up your mind? If you can't do that, would you raise your hand? Great, seeing no hands. I represent the defense. In our system of justice, the way it goes is the plaintiff has what's known as the burden of proof. If I were to ask you right now, Ms. Parker, who does the plaintiff win this case today?
Just on what I've heard, no.
And why is that?
I haven't heard all the evidence. I haven't heard both sides. Like I mentioned before, the cocaine addiction just kind of, rubs me a little bit, but, that doesn't mean that Mr. Panish can't meet you evenly or exceed you after we hear all the evidence. So, no, I don't think he wins the case just off
Thank
the
you,
bat.
Ms. Parker. And Mr. Miller, how about you? I mean, does the plaintiff win the case just in day one? Are they coming out ahead if we don't defend ourselves for what happened?
No, I trust there's still more information to hear.
And it's fair enough to say this. In our system of justice, each side has the right to present their case. And would you agree that we, the Rams, have the right to defend ourselves? You okay with that, Mr. Miller?
Yes, I agree with that.
Is there anyone who feels like we don't have the right to defend ourselves, that a lawsuit was brought and we ought to just give up and pay whatever they're asking for, and we don't have the right to defend ourselves? Does anyone feel that way? Ms. Lawson, how about you? What are your thoughts about the fact that this case had to come before a jury, that we couldn't resolve this without coming to you? How do you feel about that?
I have no problems with that.
Okay. Is there anyone who's angry at the Rams for not resolving the claims of Mr. Crady before coming into this lawsuit and taking your time? Does anyone feels like that this case should not be here before you? Anybody who feels that way? Great. Now, I realize we're in Los Angeles, that the New York jury may not have had a relationship with Mr. Crady, but is there anyone who is familiar with Mr. Crady, either being prosecuted by him when he was a federal prosecutor, or that you're familiar with him as a food critic? Anyone that knows Mr. Crady at all?
I'm a foodie, so I'm aware of him distantly.
Fair enough. Did you follow his blog, Ms. Lawson?
No, I just had heard of him, read a little bit about him, and I may have seen him on a reality show. I do watch reality shows, so I was aware of him.
Thank you very much. I appreciate that. Now, Ms. Parker, let me ask you about this, because one of the claims here is going to be a loss of future economic damages, loss of wages. Do you understand that?
I do.
And he had 450,000 followers on Instagram, right?
Right.
Do you have a sense of what that is in terms of monetary value of having that? Is that worth $1? Is it worth 1,000? Do you have any sense of what that monetary value is?
Oh, yes. I represent a lot of influencers. So we're looking for, increasing the followers, because there's like this algorithm that they use. The more followers you get, the more eyes on your page, the more advertisers you get, the more money, the more money, the more money. So I totally get it.
So let me ask you this question, then I'm going to talk to the full panel in a second. That sense of, let's say it's 500,000 followers. If you were in the jury room, do you understand that it would be the experts who testified as to what the value was of 500,000 followers, and that you couldn't offer information to the jury? That was sort of your own independent thoughts of what the value is, because that wouldn't be evidence?
I agree with that. Yes.
Then let me say this. There's going to be experts. Mr. Crady's going to have experts that say what the value of his Instagram account is. And it's going to be a certain value. And we're going to have an expert who talks about what the value of the Instagram account is, or we believe it is. Are you okay relying on what the expert's testimony is with regard to the valuation? Or are you going to bring into the jury room your own experience in the entertainment world on what that value is?
Is there a problem with me if I kind of know, since I'm in that area, even though I keep an open mind, but if I'm like, oh, Mr. Panish's expert is full of BS, or your expert is, I know it should be this, but I know I got to follow the evidence. Would that be a
great question? Ms. Parker, that's a perfect question for you all to hear, because the reality is the evidence that you get has got to be from the witness stand. You don't have to accept the evidence you hear from the witness stand, but you have to listen to it and base your decision on the evidence you hear from the witness stand. So if Mr. Panish's expert says it's 1 billion and our expert says it's 1,000, you have to judge the credibility of the individual experts as opposed to coming in with your own valuation of, well, I think it's worth X 100 because that's my experience, because that would be extrajudicial evidence coming into the courtroom. Do you understand that?
I do understand, yes.
So having said that, do you think that this might not be the best case for you to participate as a juror in, since you've got that unique skill set of information? It would be hard for you to walk away from your own knowledge.
No, I can be impartial, and I'm familiar with the plaintiff and his blogs, and I disagree with some things, but I'll put that aside and be a great juror for both sides, I hope.
And that's a fair point. In other words, is there anything that any of the jurors have heard so far that would lead you to conclude that this might not be the right case for you to sit as a juror on? Is there anyone, by a show of hands, who feels like what you've heard so far suggests this might not be the right case for you? And seeing no hands, I appreciate that. So one of the questions here is going to be damages. And obviously you heard Mr. Panish say that they're going to be looking for millions and millions of dollars for future and past damages for Mr. Crady. Is there anyone sitting here right now, having heard the information you have so far, that thinks that Mr. Crady is entitled to millions and millions of dollars worth of damages? And Mr. Abramson, if I were to ask you right now, how much should Mr. Crady receive in compensation, what would be your response?
I wouldn't even know where to begin with this Instagram thing. That's all foreign to me. So I would have to listen to the evidence on the experts. I have no idea.
And Ms. McCauley, as you sit here today, is there a number in your mind that you believe ought to be awarded to Mr. Crady, regardless of what the evidence is?
No, I have really no context to know anything like that.
Understood. And Mr. Bergman, how about you? Obviously, you're in a classical trombone world. Could you tell us a little bit? I'm fascinated by what you do professionally. What is a classical trombone musician? What do you do?
So I travel around the state with regional and playing different regional orchestras, doing gigs, wherever I can get them. But don't have a really steady job. It's just really as I can pick up gigs.
So if I came and offered you a jazz role, you wouldn't take jazz because you're a classical, or do you go to the jazz world?
You know what? I don't focus on jazz. If you want to pay me for jazz, I will do a jazz gig, but that is not what I emphasize.
Okay, thank you very much. And Mr. Kalin, I appreciate your coming here today. I realize you're a postal worker, and so taking some time off and joining us for this trial is probably a nice thing for you, sir.
Yeah, it gets me off my feet.
Have you served as a juror before?
Nope.
And do you understand that the what you make your decisions on will be based upon what the instructions of the law that are provided you by the judge in this case?
Yes.
If the evidence suggests that in your mind, at the end of the day, Mr. Crady is entitled to 0 damages for recovery of his injuries, that's what the evidence suggests is a 0 value. Would you be prepared to award $0?
I suppose so.
Is there anybody on the panel who feels just because Mr. Crady brought this lawsuit that he's entitled to any recovery?
I'm inclined to think that if a tile fell from the ceiling and hit him on the head, that there was some damage. I just have no idea of what that damage would be.
And that's a really fair point. And as I said at the beginning of my mini opening statement, we are very sorry for what occurred to Mr. Crady. In fact, a ceiling tile did drop on him. And so he did have some hospitalization. Would you be willing to listen to the evidence, Ms. Lawson, and award what you think is the reasonable value of his injuries as a result of what occurred here?
Yes.
And let me ask you this. We've heard the word, and we use the word reasonable value a lot, right?
Yes.
How would you describe the word reasonable? What is that to you?
I think that I would be relying upon the valuation information that would be provided to us.
Okay. And with regard to general damages, because there's 2 types of damages here. Special, those are the actual economic damages, your lost wages, your medical bills. And then there are your general damages. Mr. Panish referred to them as emotional distress damages, and there's no table for that. There's no quantification for that. It's really what you hear the evidence and believe is the reasonable amount of money. Mr. Miller, with regard to recovery for emotional distress damages, for you, what does the word reasonable mean?
I wouldn't know where to begin measuring someone's emotions and applying monetary value to intangible damages.
If you were asked to do that in this case, serving as a juror, do you think you can do that?
Yes, I just am curious to listen to people and weigh the evidence before me.
Is there anybody on the jury who would not be able to listen to the evidence, all the evidence, not just Mr. Panish's client's evidence, but all the evidence, and ultimately make a decision at the end of the day what the value of Mr. Crady's injuries are? Is there anyone by show of hands who cannot do that? Then I thank you very much for your participation. I don't think I have any further questions. It passes for cause.
Okay, so let me just, what I'll do is I'll talk a little bit about what my plan was, and then Paul can talk about his plan. In California, sometimes we have limited amount of time, but whether I have limited or not, I kind of use the same kind of voir dire script. The most important thing to me as the plaintiff lawyer in trying cases where you want to get a great verdict is damages. And that's why I have a series of questions that I ask the jurors about relating to beliefs and opinions about emotional distress damages, because that's always the largest part of the verdict, the general damages. And jurors always say they don't know how to do that. So we have to talk to them about it and get them to understand that people do that every day. I ask about that question about people that believe lawsuits are filed by people who have unfortunate things happen to them and the fault of others, or people that believe that are fail to take responsibility for their own actions, which in my experience has been one of the telltale signs of people that have preconceived notions about plaintiffs in bringing lawsuits. We've done a lot of focus groups, data research on types of questions and juror responses and what are the best jurors that we're looking for in a specific case. We usually, when we're trying a large case, we'll do online focus groups, we'll do live focus groups, we'll work with our jury questionnaire and our jury consultants to formulate questions that draw out jurors that we know are not going to be good for our case. And it depends on the case. There's certain issues. In this case, obviously, the guy had a fractured skull. So he's probably has what would be defined in the criteria as a moderate traumatic brain injury. But a lot of people think that if someone can come to court and sit there and function, that they really don't have any brain injury. So in most traumatic brain injuries, unless the person's in a wheelchair or they're drooling, you're not going to really be able to tell just looking at them that they have a brain injury. And in a case like this, I've represented many clients that look pretty good, even though they had significant brain injury. You have to warm the jury up to that fact and see what their beliefs are. The same thing with chronic pain. People in chronic pain, there's no picture that shows what somebody looks like when they're in chronic pain. And many people that are in chronic pain, they look okay. And if you're doing the jury selection and your client is there and they look okay, it's a slippery slope you're getting into. The mini opening statement, that's something that's been going on in California for a while. Maybe 3 years ago, the legislature adopted a statute that upon request of counsel, it's allowed. And the mini opening statement, in my opinion, is to be used to highlight the bad parts of your case, not how good your case is, how you're going to win your case, but the bad parts. The bad parts of this case are the guy had a cocaine addiction. He was on some reality TV. He looks okay. He has subjective complaints. Now, obviously, the fracture will be identified by objective findings, but you want to identify them not and say, this is the greatest case. Guy's walking in, all of a sudden out of nowhere, this thing falls on his head. He was the greatest guy. He was a lawyer. He was this and that. And when the jury then hears the opening statement or hears the other side talk, it's the same thing. Now, Paul came out right away, apologized. I normally would have a motion in limine on that. No apologies by the defense counsel. But that's, trying to curry favor and identify his client. And right away, that's good if they can get away with it. I would never let them get away with that. But that's a good technique. I like to ask very simple questions. And I'm trying to build my transcript the way it's done in California. There's a judge there. I couldn't even imagine picking a jury with no judge. And they wouldn't allow some of these questions. The judge wouldn't do it. The judge will jump in themselves and cut you off. So I like to have simple questions. I'm looking for cause challenges. I'm looking for jurors that have the bad mindset that they don't want to get money. There's too many lawsuits. People are too ready to sue. Emotional stress is crazy. Jurors are out of control. This whole tort reform issues that are in society and in the media. So I'm looking for those people, and they're out there, whether you're in Los Angeles, New York, or Des Moines, Iowa. Some places have more than others, but there are people out there that are anti-lawsuit. And I need to find those people right away, because no matter how good you are or how good your case is, they're going to be very difficult to overcome those, as I like to call them, inability, which what the statute says in California, the inability to be entirely impartial. And I like to talk about, some people like vanilla ice cream, some people like chocolate, and everyone has their preference, but if you hate both, then you're never going to be good in a case like this. And there's different analogies that we use. So I want to keep it simple. And on cause, clearly, Miss Parker, she gave it up. She gave it up that we're starting, and I like to use this starting line. People would identify that uphill battle and all this to show we're starting behind. And I usually can get a lot of jurors for costs in a jury selection if the judge allows you to ask questions, because as long as you're being nice to them and they're being honest, you're just rocking them down the primrose path, run off the gangplank, and they're in the water and they're out. But if you do it in a nice way, and at times, you know, I've gotten a little too argumentative cross-examining, but I think that, you know, another thing that we don't have a lot of time, I like to say, well, who else believes like Mrs. Parker? And 3 other people are going to raise your hand, and you get the tribe to join together and you get them out. So what I'm really doing is similar to what Robert said. I'm deselecting. I'm trying to find the bad jurors. In California, in a regular case with 2 parties, you get 6 peremptory challenges. There's 2 parties, you get 8, and it can be more and more. So with 6 challenges, 12-person jury, you need 9. You know, you can get away with a couple maybe. But as Ms. Campbell said, I'm looking for the leaders, because one bad leader is going to sink 11 other people for you. And you're trying your case to 1-person jury. And I've seen that. And that, as we go to the specific jurors, that is the #1 risk with letting a lawyer stay on the jury, because you're basically trying the case to 1 person. And usually, unless I know that lawyer, I'm not going to leave them on the jury. I have left some on that I know who they are, or I know of them. I did leave a real estate lawyer on once because I thought she was good. She turned out good for me. In that same case, I was representing a cop who had a mild traumatic brain injury, looked great, was back to work, riding he used to be motorcycle, and he couldn't be on motorcycles. So, and he looked great. Jury gave him a lot of money, and I left a police woman on the jury. I kind of liked her, but normally I try not to stereotype, but cops are tough jurors, man. I mean, they've seen, from a personal injury standpoint, #1, they see people lying all the time. #2, they see people in their worst condition. And #3, they're kind of numb because they're exposed to murders and serious injuries and tragedy, and you're looking for empathy, and they may not be the most empathetic people. So stereotyping, I would not want to have the police officer, but Miss McCauley on this case, if I had limited, I might keep her. I liked her. I thought she was nice. She seemed empathetic. And, you know, cops can be good people too. So I would have kept her. Mr. Abramson, I'll tell you, despite all your bad answers in the beginning, I kind of liked him. Okay, he's in the union. He knows that people are suing all the time. He already has the lingo going. You know, he seemed like a nice guy, even though he had some dumb ideas like about lawsuits. But he just heard that. He doesn't really know. I don't know that he really believes that. He hears that's what everyone's saying. But I liked him. He was smiling. He didn't seem like a mean agenda kind of guy. He seemed like a nice, lovable, big guy. I thought I could work with him. Bergman, he had some bad answers too in the beginning. But a musician, I mean, everyone likes a musician. Come on. His wife's the music teacher. He's a sports fan. I don't care if he liked the Rams. I wasn't really worried about that. I would in a trial, I would take him. I would be fine with him. Kalen, normally I love postal people, but Kalen, he wouldn't give it up, but I would have got him for costs. He's not giving any money. He's cheap. His wife's a lawyer, even worse. You know, he's not a good juror. I would definitely take him out. Not to mention, he kind of looked like Woody Allen. Who knows what that was? I'm just saying. So Miller, I like Miller. You know, he's kind of reserved. He, you know, just not jumping to conclusions. Bartenders, you know, they're talking to people. They see all kinds of stuff. Bartenders are bad, and stewards are bad in cases involving alcohol. I learned that the hard way. They see people in their worst. And stewardesses, or whatever flight attendants, I'm sorry, they see people in the worst. So if you got alcohol involved, you do not want a bartender or flight attendant. Cocaine, they might be okay with. I mean, I think it's kind of BS that the cocaine's even in the case. It has really nothing to do with the case, but sometimes you're faced with those issues. So in Lawson, investment banker, I mean, I don't love that, but I liked her answers. She was pretty good. I thought she was warm. I thought we could work with her. But I did think she was a leader. So if she was against you, you're in trouble, big time. Abramson was a partial leader. Miller, not really a leader. Parker, big time leader. Kayla, not really a leader. Bergman could be a leader, in my opinion. McCauley, kind of going with the flow, I think. Most cops, though, of course, you know, they're very alpha and they want to be in charge of everything. But I didn't really see her to be like that. Now, of course, I know you're making all this up, but this is how I see you in this. And, you know, you had the jurors. Some lawyer in my firm walked in and heard this. He goes, oh, those jurors are way too smart. Where did you find them? Those aren't real jurors. So, all right. So I'm going to turn it over to Paul. That's kind of just a, you know, rough thing of what I was trying to do, but I'm always all over the damages. That's what I'm about in Voir dire. Because if you got no damages, you ain't going nowhere. The jury ain't give you no money. You could try a great case. So be it. Okay. Paul, over to you.
To be fair, obviously, I'm playing the part of a defense lawyer, which is not a place I'm all that comfortable in, but I did the best I could. I'll say this, as a plaintiff lawyer and you have a mini opening, you're not trying to win the mini opening. Mini openings are really important because it gives the jury a context of what it is you're going to be talking about in your voir dire. But you don't, I had a mini opening, the first I ever did in Van Nuys, California, where I had 3 jurors in tears when I got done with my mini opening. That wasn't my plan, but it was a very compelling story of what happened to this woman when her car flipped over and she tragically burned to death with her child. And it was a really gripping story, but I had 3 jurors who were in tears, 3 prospective jurors. They were immediately removed from the panel. And so what Brian says is absolutely right. Your goal is to bring out the worst in your case, to find the flaws so the jury can hear the flaws as you're talking about your case and not why you should win. You're trying to deselect the panel, not find the people that support you, because what happens is, especially as a plaintiff, the plaintiff jurors tend to come out. They out themselves to the defense, and you lose all your best people because our clients are emotional and they're telling you why they can't be fair. I can't ever go in favor of a big corporation. So to be fair, right now I'm in 2 jury trials. Literally at this moment, I've got one that's by Zoom, fully remote. It's the first remote trial in Southern California. We started it in person, and 8 people in our courtroom went COVID positive on August 15th. And so we got laptops for all of our jurors, including the 4 alternates, and the entire trial has been done since August 15th, purely remote. The other trial started in downtown Los Angeles, and that trial is currently ongoing. We were supposed to do closing arguments today, but it got pushed to Monday. And that case was an in-person process where we had 120 jurors that went through the process to find 68 people who could sit through November 12th on a jury. We had one juror who, and I'll say this, questionnaires, Brian, I don't know about you, I love questionnaires because jurors are open and honest in what they're willing to say on a sheet of paper when no one's listening to them. So I can get really good responses in questionnaires. Obviously not a small case where a judge not gonna let you do it, but in a larger case, a questionnaire is terrific. In California, there is a 1-page judicial counsel questionnaire, which has some decent information on it. And if I can get more information about a juror before I start asking them questions, I always want to do that. Getting more is always valuable. Getting it in writing is even better because you can really get a sense of the jurors even before you begin to talk to them. So I find that having questionnaires are a very effective way. I could almost exercise my peremptories just based on the questionnaire responses, because you kind of know who you want and who you don't want by what they're saying in their questionnaires. You can use your questionnaires. What I do, and I did it today, is I only really targeted the people who I wanted to get off the panel. The folks I knew were going to be okay, Mr. Bergman, Mr. Kalin, Mr. Abramson. I liked your answers, right? You believe caps on damages are good. You're required to put up their proof. I don't want to spend a lot of time with you because I want you to be on my jury. And I don't want Mr. Panish to realize how much I like you. So I'd rather talk to some of the people who I kind of don't want on my jury, but I'll develop a report before I get you off the jury. So I want to kind of keep the people I want quiet and go for the ones I'm looking to remove and talk to you so that either I can get you off for cause, which is always my challenge because I don't want to have to use a peremptory because those 6 challenges are valuable, or if I can't get you for cause, then have you removed as one of my peremptories. The important point, at least in California, and I suspect I hear it happens in New York as well, Robert, is this jury I just picked was a case against Monsanto. It's a Roundup case that we're in trial on. And there's some very, very strong feelings about Roundup. And if I knew a juror kind of hated the company and the defense knew that, we'd ask him to go back into chambers, because you really don't want these people spewing stuff that could potentially poison the entire panel. So in California, if you've got jurors who you think are going to be problematic for you or even the other side, go back into chambers. I always tell the jurors at the beginning, I didn't today, that if there's issues we're going to ask you about that you'd be more comfortable discussing back in chambers, we're happy to go back and have that conversation so we can have an open dialogue with each other without you feeling there might be addiction issues. There might be someone who's got a friend or a relative, or they themselves might have had addiction issues they want to talk about and don't want to do that in a public forum. I always tell jurors, if we need to, we can go back into chambers and have a conversation, not in front of everybody else. So those are my general comments, Robert, and I'll turn it back to you.
They want to know what's your thoughts on the jurors.
Well, my thoughts on the jurors, I think I would, I said I would, I like Ms. McCauley. I like a cop. I'm keeping the cop. Mr. Bergman, I love your answers. I'm not letting you go. Mr. Miller is quiet, but I see Miller as a follower. I mean, ultimately what we're trying to do as trial lawyers is find, if we got 12 jurors, if I can find 10 followers and I have a couple of leaders that I think are reasonable people, I don't want 12 leaders. This panel would scare the crap out of me. If you were actually my jury, I'd be petrified. You're all too smart. So I want to have a bunch of followers. I think Mr. Miller, partly because we didn't call him in a lot, but I think Mr. Miller is a follower. Mr. Kalin, I love your responses. I wouldn't remove you. Ms. Lawson, I love your profession. The only worry I have for you as an investment banker, I had on this last panel, someone who was a director of Blackstone. And I kidded around, Blackstone could buy the state of California. Like $1 trillion is what they have under management on an hourly basis. So when Mr. Panish asks for millions of dollars, that's like a rounding error on their balance sheet. I want Mr. Abramson, who's like, oh my God, that's a lot of money. As an electrician, I could earn that like in a lifetime. So your fear with me with Ms. Lawson is that you be comfortable with big numbers because that's what you do professionally. And finally, Ms. Parker, you would worry me a little bit, even though I know that you were kind of off for cause because you were where you were. I'm worried about your viewing if this plaintiff taps into you and you feel his damages, you could really see his rise to fame and having folks work as influencers. It could be $1 million economic loss in a second, and that would worry me. So I'd probably have you not serve on this jury if I couldn't get you out for cause myself. That's all I got, Brian.
Okay, so I think we have time to take a vote from the audience as to who they would pick or who they would challenge. So, Bob, you want to go through the jurors?
Sure.
And
Okay,
so Paul?
Sure. And it was so interesting that I guess really both Paul and Brian, I look at this jury as a disaster for a plaintiff. And my thought was that Holly Parker was loosey-goosey enough and enough of a wild card that if I got rid of Levon Lawson, who is definitely, as Brian said, a potential real leader of this jury and about as unloosey-goosey as you get, and following my one stereotype on cops, because I don't think there ever has been a good plaintiff's juror cop that I've ever seen. And Brian may be right in analyzing the person, but I just can't do it. That Parker is the one that might lead the others, but I hate the jury. But okay, so for the audience, how many of you that would be the plaintiff's attorney in the case would challenge juror number 1, Ms. McCauley? who would challenge her as plaintiff's attorney?
There is a poll on your screen. Please choose an option.
Just pick yes or no.
While they're answering, they asked this question, Mr. Kellner, would you still, I probably know the answer, would you still get rid of the cop juror if the plaintiff was a police officer or spouse of the police?
No, there is a blue wall of love. And that is the only circumstance where I would accept a police officer. And I actually had a police officer client, and I had my plan to absolutely have anything blue that I could find, but the case got settled. So that is such a great point, Brian. Do we have a vote yet?
Yes, we have 55% would challenge, 45 would not.
How many of you that were defense attorneys would challenge Ms. McCauley, Officer McCauley?
While they're voting, are all the jurors lawyers?
No.
No, they're just really smart people in California.
Miss McCauley's a lawyer, Miss Parker's a lawyer, right?
Right.
Levon Lawson's a lawyer. I think all the California people are lawyers.
Yeah, the
Bergman,
California.
is Bergman a lawyer?
And Brian is. Brian, hi, sorry. Yeah, Brian co-chairs our litigation section.
He's not from Bergman, and Bergman, is he?
No.
Isn't there a firm like Bergman, and Bergman?
I think there's a Berman, I think.
Do we have a vote on yes or no?
Yes.
What is the vote, Dallaire?
35% yes would challenge, 65 would not.
Okay, interesting. Jason Abrahamson, juror number 2, how many of you as plaintiff's attorney would challenge him?
What does Jason do in real
He's the
life?
Electrician.
He really is an electrician?
No, he's a paralegal working with Karen Campbell for Louis Brisbois.
Oh, I love Louis.
It was my little joke in the middle.
Yes.
I love Louis Brisbois. They're the best.
Thank you, Brian.
But you're not going to put them on your jury.
Oh, you never know. I would take Miss Campbell.
How many plaintiffs?
What's the results?
Yes, 47 would challenge, 53% would not.
How many of you as defense attorneys would challenge him?
Okay, that's much faster. Thank you. And we have 31% would challenge, 69 would not.
Remember, you only have 3 challenges, and if you want to try to live as if you only have 2. Juror number 3, Brian Bergman, played beautiful classical trombone music for us. Any plaintiff's attorneys that would challenge him?
And we are closing in 5, 4, 3, 2, 1. 7% would challenge, 93 would not.
How many of you as defense attorneys would challenge him?
Okay, closing in 3, 2, 1. 23% would challenge, 77 would not.
We are now at Levon Lawson. Obviously a lovely person in an investment banker's job. How many of you on the plaintiff's side would challenge her?
Closing in 3, 2, 1. 41% would challenge, 59 would not.
How many of you on the defense side would challenge Ms. Lawson?
Closing in 3, 2, 1. 23% would challenge, 77 would not.
Really? Number 5 is Daniel Kalin, the postal worker, with the job we love and with the damages answers that we didn't on the plaintiff's side. How many of you would challenge him on the plaintiff's side?
What is Mr. Kalin? Is he a lawyer?
He's a lawyer and a CPA.
Oh, CPA. Well, we should have known that. Now that's a stereotype.
Yeah, as a stereotype, he's also my husband.
Triple. Trifecta.
Do we have an answer, Dallaire?
Yes, 70% would challenge, 30 would not.
Okay, on the defense side, would someone challenge Mr. Kalin?
Closing in 3, 2, 1. 15% would challenge, 85% would not.
Okay. James Miller, the bartender, how many of you on the plaintiff side would challenge him?
Closing in 3, 2, 1. 4% would challenge, 96 would not.
Okay. And Holly Parker, on the plaintiff side, how many of you would challenge her?
Closing in 3, 2, 1. 49 yes, 51 no.
On the defense side?
Closing in 3, 2, 1. 47% yes, 53% no.
Very interesting. I think for sure the panel itself is not what a plaintiff would typically want. And I think just as Brian said before, whether you're in New York or in California, challenges for cause, and of course we're limited on the time that we could follow now, but the challenges for cause I think would be very important to try to get rid of some of these people. Anything that any of the other attorneys would have to say?
I want to thank everybody, and we do a comment in the chat saying how much fun and how much they enjoyed the program. And we want to thank all the jurors. We want to thank all of our speakers, and it's great working with the Beverly Hills Bar Association and our program chairs. And thanks for staying for a few extra minutes. And I guess we'll say goodnight. Unless Bob, you have something else to say?
No, just loved working with all of you, and thank you to our wonderful, terrible jurors. And we really have enjoyed ourselves.
Yes, we have. Have a good night, everybody.
Thanks. Good night, everybody.